Thanks, Steve. Good to be here and to see you all. So just to sort of explain what I'm going to talk about today, I thought it'd start, Steve's touched on it already, but I thought I'd introduce myself a bit at the start and talk about my history, how I ended up from doing effectively the same course as you guys to being a patent attorney. Then I'm going to talk about patents. So we'll put this in the context of different types of intellectual property, and then a bit more information about patents themselves, what makes something patentable, how you can look for patents, who owns patents, how you become an inventor of patents, what the process is for actually getting a patent from filing an application to getting one granted, which isn't as simple as a lot of people think, and it's the reason I have a job, pretty much. Yeah, and then the process of getting a patent we'll talk about. I'm going to mention trade secrets because that's kind of the other option. Do you go out and apply for a patent and protect your invention via a public thing, which is a patent, or do you just keep it secret to stop your competitors stealing and doing the same thing if you're going to commercialize what you've invented? And then actually I'm going to switch tack and talk a little bit, if there's time anyway, about what it's like to be a patent attorney, what you do in the job, how you train to become one, and what the entry requirements are for the profession and things like that. So feel free to jump in at any point with questions, or we can have them at the end. Absolutely fine either way. So this is the timeline of me, if you like. So before the MSc, I did a bachelor's in genetics at Nottingham as well. Wasn't really sure what I wanted to do after that. So if I'm honest, I was looking for a way of staying at uni for another year. And the master's course, Applied Biomolecular Technology as it was then, fitted the bill perfectly in terms of providing for me actually, it was in some ways a bit of a broader introduction to biotechnology than I'd done a very focused genetics degree. But I was particularly attracted by the placements that were offered. And I ended up doing mine at Orchid Biosciences, as Steve mentioned, down in Oxford, who are a company doing genetic testing, basically effectively looking at single nucleotide polymorphisms and being able to do genotyping and assess forensics, that kind of thing, DNA-based forensics. And I was there for three months and was involved in a little aspect of their work, which was to just produce a new control that would run in their experiments, and actually worked quite nice because there was just enough time to sort of work out what was going on and complete that project. And they actually used it, I believe. They certainly told me they did. Sounds all right, Steve? Getting weird out. Can't listen to myself. There we go. So that was really nice. But one of the things that came out of my placement at Orchid was they were actually applying for a patent application for their broader technology at the time, their new way of measuring SMPs. And I was quite fascinated by it. They just kept throwing around between the scientists there, this big several page, it was this thick, basically, draft application talking about tweaks on it and what they were going to claim. And I just got quite interested in it. And that coinciding with a careers talk on becoming a patent attorney. And coincidentally for me, actually, one of my housemates, his dad was a patent attorney, which is a useful sort of insight into the profession that most people didn't have. But all these things combined together to make me think, actually, not sure I want to stay in the lab. This is something I can sort of use my scientific background for and do something a bit different. However, I didn't end up going into the profession straight after uni. I'm back. Okay. I actually applied for quite a lot of positions, and long story short, I wasn't getting any job offers for a while because you have to speculatively apply to lots of firms, and they may or may not have vacancies. So I wasn't hearing anything. So I, as a backup, sent an application to AstraZeneca to do a graduate training scheme they were offering in cancer bioscience. And I, again, cutting a long story short, ended up with two job offers, one for a patent attorney job in London and one for a job at AstraZeneca to be a research scientist. So this left me with a bit of a dilemma, which one to do. I had said I didn't particularly want to get Karen in the lab, but when I went to AstraZeneca and looked around and they had this really interesting graduate scheme, lots of people joined at the same time, it actually was quite appealing. So I decided that, well, I could go into the lab, work at AstraZeneca, and if I didn't like it, I could change my mind and become a patent attorney. But it doesn't really work very well the other way around. If you go out of the lab, leave science per se, science in the lab, and go into the patent attorney profession, and if I didn't like that, it would be very hard to switch back to a science career. So I did it that way around. And it worked very well for me, actually. I mean, I was there for 4 years, and certainly for the first 2 or 3 years, I was really enjoying it. I was happy. I wasn't necessarily thinking about the other option. But then to the later year or so I was there, I started to not be sure where the future career ladder went. I couldn't see how couldn't really see my path there. And I think I realised also that while I enjoyed being in the lab, if I did progress at AstraZeneca, I'd end up out of the lab anyway. So I got quite interested in the patent profession again. And again, long story short, ended up deciding to leave that career and become a patent attorney. And one of the team leaders at AstraZeneca, actually, his wife was a patent attorney, and I had a chat with her, and she said, "There's this really good firm I trained with called Potter-Clarkson in Nottingham. I'd really recommend seeing if they've got a job." And I'd never heard of this firm when I was in Nottingham at uni, which is quite strange. They obviously hadn't advertised in the same places in the careers guides that all these other firms that applied for had. So I sent a letter off to them, and I think it might have helped that I had this contact, because they actually wrote back and said, "Yeah, we actually are interested." So I went there, had an interview, and got a job, which is great. So that was back in 2009. And this just lists out from 2009 onwards all the different steps of my career at Potter-Clarkson, and I'll perhaps talk about that in a bit more detail at the end of the talk when I talk about how you become a patent attorney and the steps you go through, and that explains in a bit more context what it means to be an assistant associate, senior associate partner, and everything. But I'm now a partner and been there for nearly 14 years. So yeah, so seems to be working, I guess. Right, so I said I'd start off by putting patents sort of in their context within intellectual property. So intellectual property, IP, is really important for science. If you're starting up a new company, it's basically what you own, what is the key thing of your company. So protecting it and being able to commercialise it without other people just stealing it and doing it themselves is incredibly important. Patents are a key part of this. They allow you to protect the actual technical effect of what you've invented. So the technical aspects, so something new, something it works differently, it functions differently, it has a new effect. So as it says there, function, operation, construction. So long as it's novel and inventive over what was already known, you can potentially get a patent for it. And we'll talk a lot more about patents as we go on. But the other options for registered intellectual property rights are design rights. These are a bit different to patents in the sense that they're easier to get generally and cheaper, but they only protect how something looks. So they protect the actual appearance of something. So patents are all about the technical effect, so how something works, what it does, whereas designs are just about how something looks. So, for instance, the design of some packaging, like a crisp packet, that might be a registered design. Clothes are often subject to registered designs, shoes, things like that. Then the other one we have as a registered right is trademarks. You'll all have heard of trademarks. If something is a trademark, they often have TM next to it or a circle with an R in the middle. The TM basically means people want to use it as a trademark. So they want to keep using it as their specific word, if you like. But R means they've actually registered it. So they actually have a trademark protecting it. So there's a key difference there. Anyone can put TM next to their thing and say it's a trademark, but if it's got an R, it actually means something. So that protects things like words, logos, company names, things like that. Then we have the things that you don't actually register. So these are things that just come into existence on their own, and you can potentially sue somebody if they steal your ideas. So copyright, just exist once you've written something down or recorded something. Data, domain names, things like that, and also trade secrets and know-how. So proprietary information, things that you keep confidential, provided you for trade secrets, and I've got a slide on this later on, but provided you take the right steps, which there are some, if you can prove then someone has stolen that information unlawfully, you can then sue them for that as well. So there's all these various mechanisms that you can actually stop people effectively stealing your ideas. But today we're going to talk about patents, and they are generally the most useful for various reasons, which we'll talk about. So what is a patent? So some of you will know all of this, some of you won't, so I'm going to talk about it assuming you don't know much about patents. Effectively, a patent's a bargain between whoever invents something and the state. So the deal is, and that's represented by this cartoon, the inventor discloses their invention, so they put all the details of what they have invented in a patent application, which eventually gets published. So everyone can then see what they've done. But in reward for you putting that into the public domain, the state that you've applied for the patent application in will give you a temporary monopoly of up to 20 years to be able to stop anyone else doing the same thing. So that allows you to charge, a higher price for it, so you can actually recoup some of your investment and stop others doing it. You can of course license it out to other people, so they can do it if you want them to, but you will get license fees. But basically, it's a way of stimulating innovation because it encourages sharing of knowledge between different people, different universities, different companies all around the world, by rewarding it and by actually allowing people to be happy to invest millions of pounds in research, knowing they'll have a way of getting it back without, as soon as it's made public, somebody else going and doing it for much less of the price and not being able to get that money back. So some people think there's arguments that it's not a good thing, but I certainly think it is. And I mean, that's not just because it pays my salary, but it really does allow people to share that information. I think there'd be a lot of secrets kept if there wasn't a patenting system, because people didn't want to risk those competitors going off and copying it. So I've kind of introduced this a little bit on why would you bother with IP. It's very expensive, and I've got a slide later on talking about the kind of money it costs to get a patent application filed and through to grants. But it's the way of protecting your investment. It's often going to be your most valuable asset. Often with startups, particularly a very new company, they're not going to own their site, they're probably not going to own their equipment. All they're going to have is their actual ideas that the business is based on. So if they've got a patent application or eventually a patent to cover that, it's actually a tangible asset that they can show they own and is part of the valuation of the company. And similarly, it's pretty much essential for raising funds. Companies, startups, SMEs rely on investment from various sources. And investors really want proof that you've got an asset, which is your IP, but also that you can stop other people just coming along and doing their own thing. You'll see, if you watch Dragon's Den, you'll see how often they ask, have you got any patents? Have you got anything stopping someone else just coming along and doing the same thing? And I wouldn't say they always give the most accurate portrayal of the patenting system, but they do at least highlight how important it is for investors. So there's a point here saying about thinking long term, and that is a really key point, because it can take, as you know, particularly for new drugs, which is new therapeutics, something which I work a lot in, it can really take decades to get through the validation steps, regulatory approval, and actually get it onto the market. So having patents that will still be protecting your invention once you launch and some years into the future, so that you can actually recoup some of the funds, actually start charging for it and make some money, is important. And this little image of a castle kind of is a good analogy. Say your key invention is inside that castle. You can see you've got several layers of defense walls around it, and this is often how patents work. That you might have a first patent that protects your new platform, your new technology, or your new compound that's filed on day one, if you like, and that has up to 20 years that it can be protection for. But then that's going to run out in 20 years. So you might want to then, well, often you will want to then file another patent in a few years' time that protects a development of your invention. So you might have come up with a new formulation that works particularly better. You might have tweaked the compound or come up with a specific antibody sequence that is sort of another level of your invention. And providing that's inventive over what you first disclosed, you can then file a further patent application several years further on, which will then expire another 5, 6, 7 years in the future. So that might be your next ring of defense around your castle, if you like. And that goes on. You can have patents that are filed later, so they expire later, or they can just cover different aspects. So something can cover a use, something can cover a formulation, so they can cover different sort of spheres of protection around different parts of your product. It's all about building up this defense of your key idea. So bit more about what it is and what it does. So, as I said, you have 20 years as a monopoly right. A key point is that it's a right to exclusivity, not a right to use. And this is a common misconception. So you get your patent, and that's great. That means you can wave it in front of investors, and you can basically tell people they can't do what you're doing without your permission, or you might sue them. However, it doesn't mean you're therefore free to do what you're doing and not risk infringing someone else's patent. Just because you've got a patent doesn't mean that you're not at risk of infringing someone else's patent. You could have a patent to your particular antibody sequence, but someone a few years ago, maybe 15 years ago, may have managed to get a patent covering an antibody binding that protein. And so if that patent's still in existence, even though you've come up with a new inventive antibody with a specific sequence that you have a patent for, if you're producing an antibody and selling it, you might still be infringing that earlier patent that covered any antibody that bound that protein. So it's always important to bear that in mind and think separately about other people's patents. And we'll talk a bit more about how that's done as I go on. In terms of sharing the information with the world and the sort of the bargain, if you like. So patents are published 18 months after you file them. So as soon as you file a patent application, it's not immediately published. And that's actually quite useful because you might file a patent application and then decide 6 months later that actually, no, that's not the way I want to go. I actually want to change it and do something completely different, or I might actually need to keep it secret and not go down the patenting route. And so you effectively have up to that 18 months to withdraw your patent application and still keep it secret. So it's quite nice that although if you're going to go through and get it granted, you are going to have to make it public. There's a chance up to 18 months to stop that if you do want to. This bullet point, 2 to 4 years plus to grant, isn't very meaningful. It's basically, you could get a patent granted within 2 years of filing a patent application if you did everything as quick as you possibly could, took steps to accelerate the procedure, probably made your patent claims quite narrow, so you weren't trying to protect a very broad thing that you might need to argue with examiners. But usually it takes 3, 4 or more years. In some countries, it can take 10 years or more to get a patent granted, depending on how the process goes. Quite often, that's not a bad thing. Having a patent application on file is often enough for investors. They can see the potential, and by delaying the process, it actually delays the cost you need to spend on the process, which again is a good thing for a lot of companies. It has to be new and inventive, and we'll talk a bit more about the specifics of that in due course. But the key thing here is you have to keep everything confidential till you file a patent application. So that's another common mistake people make. They carry on doing everything as normal, talking to everyone, then go, oh, actually, now we'll file a patent application. Doesn't work like that. You have to have kept it confidential until then. And then what, as I've alluded to, what can you do with your patent? Again, we'll talk a bit more about this, but you basically can get things like damages if somebody else sells a rival competing product, which is infringing your patent. You potentially get a share of their sales, or if they're about to launch, you could get an injunction stopping them launching. This is all by going to court and using your patent in that way. The slide, the figure on the right, basically just shows the sort of things you can patent, and I sort of already alluded to that in terms of you can protect your actual products, methods of using them, manufacturing processes. There's lots of different aspects of things that you can actually get patent protection for. Right, it's kind of, well, it is important to note there's no such thing as a global patent. So people do band about the comment that, you know, we're going to get worldwide patent protection. Well, firstly, you can't do that because there's no patent. There's certain countries in the world that don't have a patenting system. And there's certain countries in the world where you probably wouldn't care about having a patent system. I mean, do you really care about stopping people producing your invention in Antarctica? Probably not. And there's a lot of other countries that have a very small market. So where do you file your patent application? Well, say you're a UK company, which is a good place to start because this is where we are. You'd probably file your first patent application in the UK at the UK Patent Office. You can also file for a European patent application, which, without going into loads of detail about it, allows you to file a patent application that's examined by the European Patent Office, and that's what I'm qualified to act for as a European patent attorney. And it gets granted as a European patent, but that European patent then has to be legally brought into effect in as many European states as you want to. So that's not EU states, that's actually European states that have signed up to the European Patent Office, which the UK fortunately is still one of them. And you have to spend money on each of those as well to bring them into effect. So most of the time when you get a European patent, most people won't pay to bring that into effect in all European countries. Often they'll just go for the UK, Germany and France because they're the cheapest and the biggest markets. Of course, you can get other national applications around the world. And again, in terms of deciding which countries you go for, they all cost quite a bit. So you start looking at things like where's your biggest market, where's your manufacturing base, where are people likely to manufacture as competitors, where are knockoffs coming from, and so the size of market's a really important one, and that's why the US is constantly the one that people internationally companies will go to. They'll look at Europe and the US and then start adding on different countries, you know, Japan, China are the obvious ones, and vary depending on the specifics of the actual market. We've got a slide talking about the actual sequence of things, but you do have, luckily in the patent process, you have an option of filing a first patent application, which you do in the UK. Then you have this priority system, which means within 12 months after that, you can file other patent applications around the world, which basically allows you to get one on file in your home market. And then you've got 12 months to decide where else you need to file patent applications, which just delays things a bit. And I'll talk a bit more about that as we go on. So at this point, it's probably useful to talk about the requirements of a patent. So novelty and inventive step, you've probably all heard about. Novelty, it has to be new. It can't have been found in the prior art. And we'll talk a bit about what the prior art is on the next slide. It's got to be inventive. So it's got to have an inventive step, which basically means it can't be obvious to somebody that's a skilled person in that field. And we'll talk a bit more about what the skilled person is in a minute as well. It has to be sufficiently disclosed, which means it has to have enough information in the patent application that allows someone else to come along and reproduce it. So you have to, it's again meeting that side of the bargain that you're disclosing enough of the information to be rewarded with that monopoly. So you have to put enough information in. And support is similar to that. You need to have enough data in there to justify what you're claiming. So prove that if you're claiming an antibody for treatment of cancer, for use in treatment of cancer, some data in there that proves that it's actually plausible that it does have that effect. And it needs to be industrially applicable. To be honest, most things are. So that's kind of if you've shown it does something new, you get that anyway. There are several things that are actually just excluded from being patentable by various legal statutes in different countries. And this varies country to country. But these are a list of some of the common ones. And it's the most relevant one here is probably the certain biotechnological inventions. And if we look at it from the UK point of view, there are certain things that you're just not allowed to patent to do with biotech. Human inventions that require destruction of human embryos is one. Parts of a human being, certain methods of treatment that would basically stop a doctor doing something that would save a life, things like that. There are certain things that you can't get patent protection for. But most things, if you come up with an invention, and there'll be a way of protecting some part of it via a patent to get around these exclusions, if you talk to a patent attorney. And the key thing is that you've got all this criteria. You have to convince the patent office in the country that you've applied for your patent in that your application meets all of this. And that basically is the largest part of my job. So we'll file a patent application claiming a certain amount of protection around our product, and then we have to convince the patent office that it meets all of this criteria. Right. I said I'd talk a bit more about novelty, and this just basically highlights how it really is, in terms of prior art and anything that's available to destroy novelty of your patent application. It's anything that's been written, disclosed, spoken, or made public in any way at any time before you filed your application anywhere in the world. So it really is everything. So the cartoon here shows how there was a patent application, I think back in the early 80s, which was for a new method of a dog being able to open a door. So there's a little dog button basically lower down the door that they could hit with their nose, and the door would open, which is very clever. However, one of the prior art documents that was cited against this patent application, they had to demonstrate it was novel and inventive, was an edition of the Beano from before then, which just has a cartoon of the little dog there using its nose to ring a doorbell. And they were saying, well, you know, in Beano here, this concept, having a dog do this themselves, was already known.
Prior art.
I know, exactly. So it really can be anywhere.
So some attorney somewhere has dug that out.
Yeah.
And the opposition,
yeah,
homework.
Exactly. And I mean, this is the thing. I mean, patent examiners, patent offices often won't find things like this. But if you end up in an actual contentious proceeding, so a high stakes patent invalidity trial, infringement trial, that's when lawyers start digging for all this kind of stuff and find things like that. I must admit, I've never had a Beano cited at me, so I think it's relatively unusual, but it can happen.
So was it revoked then because of that?
No, it's cited. So it's actually got it cited, I think, in the list of prior art that it was overcome. So I think they overcame it, but it's just to prove that it was a problem they had to show. They probably had to add some more features into the claim and say it was a particular type of dog button, if you like. So there's a list here with the sort of things that more commonly are prior art. So often it's poster presentations, abstracts, books, talks at conferences, journal articles, other patents, of course, PhD theses, websites. The conversation at Starbucks is an example. Again, that falls into that same category. It's almost certain that an examiner won't know about that. So it's unlikely to stop you getting a patent. But if somehow someone was able to prove that happened, which could be that the other party in the conversation that's, you know, several years down the line had a reason to be not wanting you to have that patent, they could say, well, we have this conversation, and if they've got any way of proving it, which again, it can be difficult, but it could potentially be used to show that it wasn't new because it'd been publicly disclosed in a public place where other people could have heard it, basically meaning it's publicly disclosed. So it's very important to file a patent application before any of this happens. So before you talk to anyone, you can talk to people, but just get them to sign a non-disclosure agreement first so that you've got a piece of paper saying it's a confidential discussion, so not a public discussion. Last point on there is that you only need one difference for novelty. So it can be a lot of stuff can be known, but you can still get a patent application. For instance, the example there is known drugs that have been used for loads of things that everyone knows about. If you come up with a new use for it that no one else knew about it, so using previously a cancer treatment, then for treating asthma, that use of that drug for treating asthma is potentially patentable. You get your own protection for that. So inventive step is the other side of the coin, and this is a lot more subjective. Has a lot more case law on what it's based on, and provides a lot more work for patent attorneys like me. It's all based on this legal fictitious person called a skilled person. and what they would think in terms of whether something was obvious over what was known before. So you get all your prior art, all these different publications, Beano articles, etc., etc., and then you judge whether the skilled person would look at those and go, actually, what you've done, that's obvious. I would have done that anyway, or it's inventive or surprising. So this skilled person is an imaginary person. It's basically not you. It's not a normal scientist. They have a knowledge that is basically everything in the world. So they've read every document that's available, which of course no one has. They can follow instructions. So if a document says you should now go and mix A with B and you'll get C, they'll go and do that. But they would never have any innovative nature. So they wouldn't go, oh, but what happens if I mix D in as well? Unless there was some instruction from someone, they wouldn't think to do that. They can piece together different instructions for different articles they've read. But only if there's some direction for them to actually take A from there and B from there and mix them together. They can be motivated to try new things like this, but there needs to be a motivation. So say one document was in I don't know, say it was a document that was from the world of horticulture, and there was another document from the world of cancer therapies. And one said about using compound A and one said about using compound B. Mix them together probably wouldn't be any motivation. But if the one in cancer said, often this would be, it might be useful to also for horticultural use or something, there might then be a motivation to consider that document and mix together. You see how you build up these kind of arguments, which can be weak, can be strong, but it's what we spend a lot of time arguing about. So if there's no motivation, and if it was not obvious to the skilled person, it's considered inventive, and you can then get a patent for it potentially. Another thing that helps you say something's inventive is if there's something in the prior art, an early document saying don't do this. So if there's something saying, well, I thought about mixing A and B together, but as everyone knows, that's most likely going to cause a disaster because of this. If there was something written saying that, and then you did mix A and B together and get something inventive, that would help. And the other thing is surprisingly good data. That always helps. If you mix A and B together and it's, well, you'd never expect it to work like that, that also helps inventive step because it's something surprising, something new that wasn't predicted. I've just got some examples here of the sort of things that are novel and inventive, some which may be surprising, some may not be. Just running through them, I mean, you've got different media here that you might grow bacteria in. I mean, the key thing in this example is that the new media you've created allows improved growth of a particular bacteria. So it's not just an arbitrary difference, it's actually got a technical effect. It does something better, which helps you get inventive step. Similarly, you've got different positions of a fluorophore on a nucleic acid. Allows better discrimination, different buffers there for improved stability. There's a combination of drugs example here, and the key thing with this is you can't, if you a known drug for treating cancer and a known other drug for treating cancer, mix them together. It's only inventive if there's a synergistic effect that wasn't expected. If you just get an additive effect, it's very hard to argue that's inventive and not obvious. But if it does something much more than the sum of those two parts, so it's synergistic, there's a potential for an inventive step in a patent application. Just a few more on here. One, the R groups thing. So often if you have disclosures of chemical structures in a general sense, particularly in earlier patent applications, but if you found that just by tweaking one little R group, making one minor difference, actually has a big impact on how that compound works for a treatment, for instance, you can then potentially get novelty inventive step protecting that specific tweaked compound with the changed R group. And then the other things here are just obvious things. I think one thing there is worth saying is the selection of a temperature range. So if you had an earlier disclosure that said that a chemical reaction worked generally between 10 and 30 degrees, if you then found that actually if you ran it specifically between 10 and, so say, I don't know, 15 and 18 degrees in that smaller window, it had a much better effect than any of the other temperatures. you potentially could get a patent for that small window because you've shown that it's inventive to go to this particular sub-range from what was known before. So it can be surprising what you can get a patent application for as long as you've got a difference and it's not obvious. Right, so the next one, this was, if you remember that list we had of things you had to get through to, I had to argue is the case for a patent to be granted. The next one was sufficiency. And this is making sure you've got enough information in the patent application. You've done your side of the bargain. You've shown the detail to allow someone else to produce it. So the test is you have to have described your invention clearly and completely enough. For this fictional skill person, it's that same robot type person that was on the other slide to be able to make and use your invention. One key thing is you can't make that skill person go out and have to do further research themselves. You have to put enough information in there that they can do it pretty simply. A couple of key things that need to be in there to meet this requirement is these days you really do need to put your protein or nucleic acid sequences in the application. You can't go ahead and get your patent protection and keep your sequences secret with the hope that that stops competitors recreating it. The deal is if you're going to get your monopoly, you need to share that information. And the other one similarly is if you've come up with a new engineered microorganism, you almost certainly would need to, and you're going to try and get patent protection for it, you need to deposit it at one of there's various depository institutions around the world that are signed up to it's called the Budapest Treaty, but it's a treaty that patent offices all know that if you've deposited your particular new microorganism there, that meets the requirements of sufficiency for getting a patent granted covering that microorganism. And this makes sense because there's no way, if you've got a new genetically engineered organism that you can't really describe on paper, the only way of putting that information in the public domain is by actually depositing it somewhere that a third party can then go and request a sample of it and actually do their own experiments on it. So again, it's that, fair exchange of giving something back to the scientific world in exchange for your temporary monopoly. This slide bit on the right is just showing an example of, it's actually one of my colleagues, Sarah Holland, who's now a patent attorney, who used to work at Nottingham University as a postdoc, and she deposited that yeast strain, I believe, in 2010 as part of her, I think there was a patent application filed on it, I'm not sure. The final one on this is support and data, and this is to justify that you have done what you say you've done, particularly if you're protecting a new treatment, to show that actually it covers that. And the test here is that it must be at least plausible, based on the data in the patent application, that it does what it says. So you don't have to prove it to the umpteenth degree, and as it says here, it's probably a lower standard of proof than for a journal publication. If you think about it, if you've just come up with a new compound that you think is going to be useful for curing cancer, you kind of need to file your patent application before you talk about it to anybody, and certainly before you do any clinical trials and it all becomes public. But at that stage, you're not going to have complete proof that it's a reasonable cancer treatment. So you need enough data in there to make it plausible that it will end up being a cancer treatment. So this is in vitro data, obviously, potentially some early stage in vivo data, so maybe some mouse models or something, but something that makes it plausible based on what you've shown is going to work. As there's a point here saying that bland data can be very useful for patents, and that's because you've got to support the breadth of a claim. So if you've got a new compound, you think it might actually be useful in treating any cancer, which might be quite unlikely, but if you think that's the case, you really need to make that plausible, have shown it working in more than just one cancer cell line. So if you've done it in a prostate cancer cell line, it's hard to argue it's plausible that it then would work in any kind of cancer unless you've done it in another line or something, well, one or two more lines at least. So it can be quite bland data, sometimes just repeating things in different lines or in slightly different conditions, just to prove that you shouldn't have your patent claims limited to that particular thing. So this all comes down to how broad you go with your patent protection, what data you're likely to get, and how broad you go with your claims. And as I mentioned right at the beginning, you can file an initial patent application, and 12 months later you can choose where you go around the world. At that 12-month point, you can actually add more data in. So that's something that people think about when doing patent applications, that we have X amount of data here, but we're hoping to get some more data within the next year, and that can go in at that stage. If it's going to be, say, I don't know, 16 months before you get that next chunk of useful data, it might be worth holding off, keeping every secret for another 4 months, so you can actually get it all in on this first, and then 12 months later filing. This is just a quick slide on ownership, because it's very important, obviously, who owns a patent and a patent application, and it's all determined by who invented the invention. And to make sure that the ownership is correct, you might need to have assignments done from particular inventors to whichever company's filing the patent application. It's very expensive to file a patent application, so only certain companies might want to do it, and it might not be that all of the inventors work for that company. So in that case, you might need agreements done. As the cartoons here demonstrate, inventorship determine the ownership. But the key thing is inventorship isn't the same as, quite often when you file a patent application, there's an equivalent journal article that's going in at the same time, or hopefully, well, at least the day the patent application is filed, or later the journal's going to publication. And that'll have potentially a long list of authors, maybe, I don't know, 10, 15 different people that are named as authors on that manuscript. It's very rare that all of those authors on the equivalent manuscript would also be inventors for the patent application. The actual inventors are those that are devisers of the invention. So it's not just someone that ran some blots for that particular study, or lent them some lab space, or just looked at something to check they agreed with it or something like that. It's the people that actually sat down and came up with that idea to tweak that compound or to do that new use. So it may only be, I don't know, 1, 2, or 3 people of a subset from the authors on a journal article. As I mentioned, ownership is affected by employment, so a lot of employment contracts specify that any IP, any inventions go to the employer. It makes things simple. But if you start doing collaborative agreements or having consultants work for you, it's very important all of those make it clear who owns the IP. And if you end up with inventors from different institutes, as is mentioned there, you end up with a co-ownership situation. And the ideal situation is that one owner, so one company, is going to be the one that files the patent application and pays all the money and ends up with the patent, and then you assign the rights from the inventors that work for the other company to that company. But if that can't be agreed and you end up with 2 co-applicants for a patent application, which does happen, it's important to agree who's going to lead it, who's going to pay the money, and who's going to be in charge. So it's something we try and avoid at all costs, because it just becomes really problematic having 2 people telling you what they want to do. Right, this is the promised diagram of how the timeline works for filing a patent, and some information on costs as well, which sort of highlights how expensive it can be. So starting over at the left at time 0, so this is when you might file your first patent application. You've kept everything secret up to then, and you're going to file a GB UK patent application at the UK Patent Office. Now, to get a patent application professionally drafted and on file at the Patent Office, which involves a lot of collaboration between patent attorneys and inventors to make sure they understand what's going on, understand how it's different over the prior art, and get it all written, work out the breadth of the claims, etc. It tends to cost, I would say, well, here we've got between £7,000 and £9,500. I mean, that's a reasonable estimate these days. So it's a lot of money to pay up front to get a patent application on file. There's a step in here at 3 to 6 months. You might have a search report done by the UK Patent Office. That's optional, so that might happen, might not. But the key thing is at 12 months, you then have to make this decision about filing further applications around the world. There's a really handy mechanism called the PCT, Patent Cooperation Treaty system, which allows you to file a so-called PCT patent application, which has the power to become a patent application in virtually any other country around the world later. So rather than at that 12-month stage having to name all the different countries you want to go into, you can file this international PCT application and then later on decide which countries that turns into. So most people do that. and that ends up costing, I don't know, around £7,000 it's a lot of official fees for this international application, but it's much cheaper than filing a Chinese, Japanese, US, etc., all at the same time at that 12-month stage. So that's the 12-month stage. As I said, you can add extra data in at that point, and there's just this really useful thing in the patent system that at that up to that 12-month point, you can claim back and keep the date of your initial GB filing. So if anything was published, any new prior art, any new Beano editions published between 0 and 12 months, as long as you're claiming priority back to that first application filed at 0 months, you're safe from those publications. So that international application, say you've gone down this strategy, at 18 months from time 0, so 6 months after you file it, it will publish, unless you withdraw it, as I said. So that's when your invention is made public. It's when you've fulfilled your part of the bargain. There's always a search report issued by the international PCT system, creates a search report. They do a search, a really thorough search of any prior art themselves, and report that to you and flag up any problems they think there are with novelty and inventive step. That happens around the same time as publication. And then the next big step is basically 2.5 years after filing, after the original filing, when you have to decide what you do with that PCT application. And this is where you decide which countries around the world you go into. So each of these countries probably on average costs around another £5,000+ to file in. That's official fees, things that require amendment on application. For countries like China and Japan, you have to have the whole patent application translated into Japanese or Chinese, which adds a lot to the costs. So it gets very expensive at this stage. So often companies just choose their particular key markets. So the key ones are there. Europe, it's your local market, and it's a big market. It has the potential to go into all European states if you want to. The US, China, Japan, you'll make a decision at that point and pay those costs. We've simplified the next stage massively and just said it's about 42 to 54, which is a very specific range. But anyway, it's probably another 2, 3, 4, 5, 6 years after that you might get to grant in each of these countries. Between filing in each of these countries and getting to grant, you'll have examination happening in all these different countries. All of their individual patent offices will throw up examination reports saying why they don't think your patent application meets the requirements. And my job, patent attorney's job, is to deal with all those examination reports coming in from all those different countries. So that obviously gets quite expensive because there's exam reports coming in left, right and centre, all needing dealing with, all cost money in terms of official fees and legal costs from patent attorneys looking at them. So during that period on the right, it's very expensive. So this is why companies are quite often happy for things to take quite a long time, and why they always run up to these deadlines to have everything happen as late as possible, so that they're delaying the decisions on which countries and costs until later in their company's lifetime. So they might have more investment, more money, and crucially, more idea whether the actual invention is going to be commercially successful and this is worth paying for. But the key point is, once they've gone past the 18 months, the invention's in the public domain, so that it's done its bit for sharing that innovation with the world. So sort of stimulating innovation. When we look at, so if you see a patent application or a patent when it becomes a patent, just thought it was useful to know what you'd be seeing in it. So what makes up an actual patent? So this quite a thick document. They're often like 100 pages long for a biotech patent. So, quite a lengthy document. Officially have a title. They tend to be quite nondescript because they deliberately try not to give away too much information. So, for instance, when I file patent applications, I often call them things like biological materials and uses thereof, just so when it first comes up in the first year or two, there's no hint what the actual invention is. You need an abstract, which effectively is a description of what it is. That doesn't get published till the 18 months. And that basically is effectively what you're claiming. So a paragraph summary of what your patent claims are. You need some background, so saying what's already known from your side. Well, you don't need it, but it's best to have it, because it's best to, in your patent application, say, this is what's already known, this is what we've done, this is why it's inventive over it. You need a description of obviously what you've done, what your invention is. You need to define all of the terms you use in your claims, so it's all clear what everything means. You need examples showing the data, showing what you've done and the data. So this tends to be the bit that looks like a journal article. So you've got a results section, you've got lots of figures, you've got explanations of what they all show, and your references, and so that bit's all very like a journal article. And then crucially, the claims. So the claims is the important bit for a patent. That's what defines what the patent's protecting, whether you fall within the patent or not. So the patent claims define the invention. They show what the scope of the invention, the protection is, and they always start off with a broad claim. So if you ever look at a patent application or a patent and you want to know what it protects, just look at claim 1. That will most likely be the broadest claim. And if you don't fall within that claim with what you say, you kind of don't need to look at the other ones because they're just fallback positions that are narrower, and that's what are called dependent claims. So they import certain. So I've got an example actually on the next slide, which is a better way to explain dependent claims, but they're basically in there. So if you do need to amend your patent application or your patent, you've got fallback narrowing claims you can move to if you need to. So this is my example of a patent, and it perhaps is big enough for you to see. So I was trying to think which one to share, and I went back to when I started in the profession, and I did a bit of work for the University of Nottingham then, and I think this was the first patent, one of the first patent filings I worked on. So I thought this would be a good one to share as an example. So on the left, you've got what a front page of a patent looks like. So this is a European patent. You have the patent number at the top, and then you have various information going down, and you've got, for instance, the date of publication of a patent at the top, the date of filing, which is the actual date that the 20 years runs from. So this one was filed in July 2006. So you know that if they paid all the renewal fees and kept it in force, it will expire at the latest 2026. So that's some key information.
Keith Campbell's on that.
Sorry?
Keith Campbell's on that.
Yeah. Yeah, so this is, I actually didn't work on this year. I did check, and I worked on the corresponding US one. I think this was granted just about the time I filed it.
Ramiro as well?
Yep. Yes, you've got Ramiro, Berrio, Keith Campbell, and Andrew Johnson from Nottingham.
Interesting.
Yeah. It's actually easier to see on there than on here, weirdly enough. So this is what the front page looks like, and as Steve's pointed out, those names are the inventors who are always listed on your patent. The proprietors listed above that, which is the University of Nottingham, so they own the patent. It's got a priority date up there, which is the date that first, which has got a GB number. So that was the UK patent that was filed right at the start that it claims back to. And yeah, it's got that nice title, very simple. In fact, it's the exact same title I was talking about. And that's because the patent attorney, which is the representative down here, is Jane Wainwright, who is actually my boss, or was my boss, who trained me. So that's obviously where I got her titles from. So that's your classic front page of a patent. It tends to have all that information on. These are the claims that were granted in that patent. So it was all to do with a method of producing a reprogrammed cell to stop having to use human embryos, basically. And through the patent application process, there was various arguments with the patent office in terms of what was new over what was known before. And I think I had a quick look at this yesterday, actually. The key thing in this was that it was to do with. So if I just go through the claims before we go into it in detail. So it's a method of producing a reprogrammed cell or a reprogrammed cell nucleus, comprising exposing a permeabilized differentiated cell, or the nucleus of one of those, at a particular temperature range, to a cell or a cell extract derived from an oocyte, an egg, an ovary, an early embryo of a cold-blooded vertebrate, and when the cold-blooded vertebrate is an axolotl or a sturgeon. And the key thing was here that it's the first time that we'd shown that it was used if you use a particular type of cold-blooded vertebrate, specifically an axolotl or a sturgeon, to an extract from that to actually do this method of reprogramming. It was the first time that had been shown to work. So that was how they got their patent. So that's the broadest claim one. It shows what the broadest scope of protection they've got. If you came up with a method that you did it at more than 30 degrees, you'd be outside that claim. Or if you used an extract that was from something other than an axolotl or a sturgeon, you'd be outside that claim. Claims 2, 3, 4, and 5 are dependent claims. These are fallback positions, so they would be useful if ever this claim was attacked and in litigation or something, and you needed to amend it. You could fall back to these narrower claims where they've added in extra features. So they've said, for instance, in claim 3, they've specified that the reprogrammed cell must express OCT4. Claim 4 must express nanog. Various fallback positions. So that's an example of how claims often work. So when you've got your patent granted, what happens after that? Well, as I said, it's a national right. So whichever country you've got it granted in, it allows you to prevent competitors using that patent in that country. You must pay annual maintenance fees to keep a patent in force. So this varies between countries, and it's actually not technically always annual. So most countries, every year you have to pay a fee to keep your patent going, which probably varies between £200 or £300 and up to £1,000 or £2,000. So it's not an insignificant amount. So quite often it gets expensive to keep these patents going. So if they're not actually useful to you, you might stop paying the fees and let them lapse. And in some countries, like the US as an example, you only actually pay it 3 times. You pay a renewal fee at 3 years after grant, 7 years after grant, and 11 years after grant. But anyway, the important thing to know is you have to keep paying fees. If you end up having your patent infringed, if you want to stop someone doing it legally, you have to actually litigate before a national court. So that's when it all gets very expensive, because of course you start having to involve barristers, courts. So it's not just patent attorneys, you end up with lots of people all involved. And the next point is that it leads on to that. I mean, patents can be opposed, invalidated, or revoked. So you get your patent granted. That is in a way only step one, because it could be challenged. At the European Patent Office, within 9 months of a patent being granted, so like that example I showed you before, after grant, any third party can file an opposition and try and knock it out at the European Patent Office. And that happens relatively frequently. I think about 5% of patents at the European Patent Office might get opposed. It's actually quite good fun as a patent attorney, because you get to go properly into especially if you're opposing, because then you've got nothing to lose, because you're basically then arguing why someone else's patent isn't novel, isn't inventive, isn't sufficiently disclosed, isn't supported. You get to look everything the other way around, and it's actually quite nice to do that for a change. If your patent that you wrote and you got granted gets opposed by someone else, it's horrible, because basically your baby that you've written is getting attacked for everything under the sun. So, but it's interesting, and it's quite good fun. But it does mean that there is a risk, and it's why it's important to be sure you get a quality patent application on file and get a strong patent. And if you ever go to court and sue someone for infringing your patent, they almost certainly will counterclaim that your patent's invalid. So your patent will then get attacked during that as well. As I mentioned, they're personal property, so you can license to other companies, you can sell them to other companies, you can even get a mortgage on them, so they're very useful financially. This goes on with why you can make money from them. As I said, out license, you can work with other people to bring your invention to market, sell it. The key point there is probably seeking third-party investment or funding based on your patents. As I said, companies really do need this kind of thing to prove to investors that they're worth investing in. Right, freedom to operate. I did say I would talk about this. This is the other side of patents. So ignoring you getting patent protection for your new product, are you going to have a problem from other people's patents? So the only way to really work that out is to search for granted or pending patent applications. So where do you do that? When do you do that? And how do you do it? It's incredibly difficult, because you can't prove a negative. You can't say there's definitely nothing anywhere in the world that's a problem. It's just impossible to do. It would be so expensive, and there's always new patents applications publishing and granting every day. So you'd never have a definitive point to be able to say that. So companies tend to look at their key competitors, look what patents they've got. They may do searches based on the key. I don't know if you've come up against a key, a new antibody against a key target, you might do some searches for patents relating to that target, but try and keeping it narrow. You need to do top-up searches probably every year in case new patents have been filed. It's important for investors to show you've at least looked at this. So companies tend to take quite a strategic route and basically look at the most likely problems, but they can never say there's definitely not a problem, but they just look a bit and make sure they keep aware of the most likely places there could be patents that are a problem. It's also important to know what you would do if you found a problem. So say you come up with a patent, find a patent that covers what you're trying to do. One of the things you can do is potentially try and design around it. So that patent only covers a certain thing. So if you could tweak your compound, tweak your antibody so it's slightly different, so it no longer falls under that patent, that would be a way around it. Perhaps more commonly, particularly if you're further down the path of generating your invention, is to seek a license from that third party that owns the patent. This came up with one of my clients last year. Actually, they found a patent that was a complete block for what they were doing. It'd just been published, and if they decided to sue my client, they would clearly have been infringing it, and they needed to launch their product. So they actually got into license negotiations with the company that owned the patents. They approached them and said, "We found this patent. We know it's quite relevant to what we're doing. Would you be interested in doing a license deal?" And fortunately for them, the other company wasn't really actively pursuing that research themselves. They were quite happy to do a license deal, get a share of my client's sales as a royalty, to make some money. But then, of course, by having a license, they would never sue my client for doing what they were doing. The final option there is where you could just go ahead anyway and just say, okay, there is a patent, but it's, I don't know, it might be from a company in a completely different sector that would never know what we're doing, and I don't think they're the sort of company that would ever sue, so we're just going to go ahead anyway. There are obviously risks with that. What are the consequences of being caught? Would they then sue you? It's a risky one. So some people do that though. They just go ahead and do it. I said I'd talk about searching for patents. So often, searching for existing patents and applications, often if you're doing a big freedom to operate type search, people will use external searching companies that actually specialize in doing this, and you pay them a certain fee and they will design a keyword search and generate a load of search results for you. But you can, of course, search yourself. The second point here actually is filing your own patent application, because if you file a patent application, that necessarily will be a search report generated by the patent office you filed your patent application with. And they're very, very good searches, so they will find the most relevant things. But they will only be searching from what's relevant for your patents. They won't be searching necessarily for broad patents that might stop you doing what you're doing. So it is useful to do some own searching yourself. Probably the most useful one I find for searching is something called a SPASnet, which is a search tool on the European Patent Office website. But it has the whole world's patent information in there, so you can search for any patent applications or patents around the world by title, by the name of the proprietor, so who owns the patent, by the inventors, by the dates, and by keywords in the abstract or the title. So it's quite an effective way of doing it, and particularly if you're looking for patents owned by a particular company, if you just write the company name there under priority and search, you'll get a nice list of all the patents that company has filed, and you can click through and quite easily see the claims and everything for those particular patents. So it's one of those things that if you're interested, go have a look, have a play with it, and you'll quite easily, it's quite intuitive how you'd work it. There's an equivalent system on the World Intellectual Property Office, as it's called, which is, I don't like that term because it's the office that runs the PCT system, but it isn't completely global. Not all countries are part of it, so I don't like it being called World. But that patent office has a similar system to the SPASnet that you can use as well. And then Google have a Google Patents search tool as well. But I find the SPASnet one the most user-friendly from my point of view. Finally, I just said I would briefly mention trade secrets, just because this was the other option. So if you don't want to file a patent application, which you might not want to do because of the cost, or you might not want to do because you want to keep what you've invented secret forever if possible. The classic example of that is the recipe for Coca-Cola. They've never patented that. They've just kept it secret because they don't want to only have 20 years of protection, funnily enough, which has obviously worked out quite well for them. The advantages are that it's cheaper, and as I've said, it can last for as long as you keep it secret. The real disadvantages are, of course, the risk that it gets out somewhere. There's a lot of potential leaks from your company, and it's very difficult to license it because it's very hard to do a license deal without being able to talk about what it is, because you've got to keep it secret, so it becomes tricky. Things can be a trade secret if it's not known information, has value, and particularly there's some legal steps you have to take, which means you have to take particular steps to keep it secret, which are practical and legal. So you have to have done various things that make it easy to be kept secret, that it's well documented what your trade secrets are, this is within the company, and that only certain people have access to it, and that you've got safeguards to stop people taking that information. So it's not just a case of saying, I'm going to keep this secret. You actually do have to do a certain amount of work to make sure you've demonstrated you are keeping that secret. But if you can do that and meet those requirements, it actually works very well as part of your IP strategy to keep something secret as a trade secret and file patent applications and other things. So you keep some information back, share some information, get monopoly on that. You can do licensing with that, but keep this secret. And people often do that for processes and things that are more easy to keep secret. It's hard, obviously, if it's something that can be reverse engineered from a product, that doesn't work as a trade secret because somebody can work out what it is anyway. So that's why a patent will be the solution in that situation. That is my patents talk. I got a few slides now about being a patent attorney. Do we want to go straight into that? Do we want to break or run out of time?
What do you reckon, Gary? Should we go 5 minute stretch legs or go straight in? 5 minute stretch.
Sounds good.
Do you want to do the coffee bring over?
Yeah, that'd be great, actually. I mean, the next bit's only going to take 10 minutes or so you can just wait if that makes more sense.
Yeah.
Oh, it's up to you. I might have to head back. I mean, they're gone now, so.
Yeah. I meant just in terms of getting a coffee. I'm happy to wait if that's easier. Bit of a walk.
Okay. You can go over to.
Oh, what, homemade coffee or?
Yeah, I think so. Oh, well, sure. No, what we'll do is we'll take you over there. From there we'll go grab some lunch.
Sounds good.
That's right.
Sounds good, yeah.
I think the bar notes at 12:30. By the time we're all right.
All right, well, have a good Christmas, though.
Yeah, you too.
Lecture and
yeah.
See you
So you don't want to become a patent attorney now?
Oh, well.
He's not heard the bit about becoming a patent attorney.
It's a funny story, but for another time. I mean, to be fair, yeah, it's personal. But, I feel like the older I get, then do I have the the patience to go through the training process?
Yeah.
I mean, yeah, we'll see.
Yeah. No, I get that. I mean, for me, I was 28 when I joined. So when I started doing, and that was a good amount of time since I'd last done an exam, which was quite a surprise.
It's fine, do mix of people and.
Oh, 2008.
Yeah. Well, 2000. Yeah, I was 28. Yeah, joined in 2009. But Sarah Holland, actually, who was at Nottingham as well, who was the yeast strain depositor.
Right.
She was she's actually a year older than me, and she joined 5 years after me. She was quite late to join the profession, but she's not found it a problem. So yeah.
Yeah, I've got many friends actually. They're patents.
Got some friends.
Yeah. Not Potter-Clarkson though.
Okay. Yeah.
Forces.
Yeah. What, in Birmingham?
Yeah.
Other patent attorney firms are available.
Yeah. No, but are there any other ones in Nottingham?
There's the main one is Adamson Jones. Who it's really weird. They've just moved into the offices I used to work in at Potter-Clarkson. I mean, Nottingham's not that small a city, but but Adamson Jones, they're quite a lot smaller though, because we're we're 200 people in total, whereas they're more like 15, 20, so a lot smaller.
Who's the people in Birmingham?
Forrester, there's quite a few companies in Birmingham.
Somewhere just a group in Birmingham.
There's Forrester's, Barker Britell is another big one in Birmingham. Marks and Clark are in Birmingham.
This top floor, this not far from New Street, the glass building.
Yeah.
Would that be Forrester's?
Possibly. I've not actually been to any of their offices in. You don't tend to get.
Yeah. I was involved, but then it was a US patent, a lot of money to go to the States and things, so I pulled out.
Yeah.
Because you know what American attorneys are like.
Oh, yeah.
Start researching into your personal history and everything else. It's terrible.
Yeah, it's a whole different world when you get America. Yeah, the US side of things. They've got discovery, obviously, as an option, which isn't there for when you're doing the oppositions in Europe. And yeah.
European part, Munich office is fantastic.
Yeah. No, I've enjoyed that. It's one of the saddest, in a way, sad things that's come out of the pandemic that we do all those hearings by video conference now. Well, most of them. Yeah, that's the default now, is they happen by video link. So it's good from an environmental point of view, and from you don't have to worry about travel and hotels and everything. But it's a bit kind of ruins the magic of it a little bit, because you just going to a room.
Because it's fantastic. You treat through all this.
Yeah. Well, now you'd come to our office in Nottingham and go to a pub in Nottingham afterwards.
Yeah, so just for a screen in Nottingham.
Yeah, exactly. Yeah. Is that everyone back?
2, 4, 6.
Yeah.
This
Great.
is only last 15 minutes.
Yeah, if that. I forgot to say, has anyone got any questions on the first part? No worries. Thank you, doke.
Okay, just 5 minutes.
Yeah, this won't take very long because I've talked about some of it already. So this is basically adapted from a careers talk I've given a few times, but basically how you become a patent attorney for those of you that might be interested. As Steve said right at the start, and as a lot of people don't know, you need to have a scientific or engineering background. So you have to have a science or engineering degree. You can't take the exams and become a qualified patent attorney if you haven't. So you obviously will meet that because you have one. To get into the profession these days, it's a very competitive process. So realistically, employers tend to look for easy ways to ignore certain candidates. So I think that you realistically need a 2-1 for your degree. It's still the case that a lot of employers do look, because you've got so many applications. It's a way of distinguishing one person from another. So having a PhD or industrial employment of some kind is preferred. So, for instance, I don't have a PhD, but having that time at the lab at AstraZeneca, I think, sort of provided the same skills. But saying that, my first trainee I recruited, Helen, she was straight out of university. So I think as long as you've done that degree, you've done some time in a lab. So it's not essential, but it can be useful. The key things, though, in terms of skills, you really need to be able to technical information. You've got to hear about new inventions, understand pretty straight away how it works, how it's new, how it's different to what was known before. And it's often new stuff. Well, it's by definition new stuff, but it's often in different fields you're working on last week. So you've got to keep your brain in gear quite a lot on technical information. English language skills are very important, because a patent and the patent application it's all down to how it's written, and it falls or survives or falls based on the words that are used to write it for the claims and everything. So obviously language skills are key to be able to do that right. Attention to detail, the same thing really. If you miss out a particular word or miss out a particular thing or miss a deadline, you could lose your entire patent application, or you could get a patent application or a patent that covers the wrong thing. So it's very key. And pressure is a thing with the job. As I said, when you get to that point where you've got patent applications going on in all those countries around the world, you've got deadlines being set left, right, and centre by all the different patent offices. Every exam report has a deadline for responding to it, and our clients never seem to have the information ready to respond until about 2 days before the deadline. So you end up with all these things happening at the same time. And also, often, if you've got to file a new patent application, you might only hear about that and get the information for it from your client like the week before. So then you have a deadline. They're going to publish in a week at a conference. So you've got to get the patent application prepared and filed before then. So you can have certain weeks that are really, really busy, even quite stressful, but then other weeks that aren't. It's just sometimes there will be pressured situations. I think that's being able to deal with that's pretty much essential. There's two routes really into the career. So there's the private practice route, which is what I do, where I work for a particular firm, so Potter-Clarkson, where we sell our time to lots of different clients. So I work for all kinds of different clients, actually all around the world, and they pay for my time. But it means like today when I get back to the office, I'll be working on one client. Tomorrow I'll be working with a different client. Well, to be honest, I might work on up to 10 different clients in one day, doing lots of different things and dealing with things that come in. So it's great for having a wide variety of work, lots of different clients, lots of different inventions, and that's why I like it and why I prefer it. The other option is you go and work in-house for a particular company. So big companies that generate a lot of IP will employ their own patent attorneys to work for them. So AstraZeneca, GSK are examples. They'll have a whole team of patent attorneys. And if you have particular expertise in the same area that they work in, you can be quite attractive to them as a trainee. But equally, it allows you to become very skilled in a particular area. So you could become an absolute expert on antibody patents if you're working for that area of AstraZeneca's business. And I can see the appeal of that you get used to one particular area, you understand it completely, and that's what you work on. But I don't know, in some ways, there's the idea of actually switching around and looking at lots of different new types of inventions, I think is quite appealing too. So there's two different routes there. And actually, the people quite often switch between, they'll train in one and then try out the other one to see if that's better. And, so people do move between the two. Just an example of who we work for in terms of client size. So as we actually work with some of those companies, they are clients like AstraZeneca. So they still use patent attorneys from private practice when they have too much work at times, or certain areas that they're not particularly experienced in, like oppositions and things, they tend to outsource.
It's happened with Merck actually.
Yeah.
When they lost the first round, they brought in private practice to try and help sort it out.
Yeah, and we tend to have more experience in oppositions because we work for more clients. So they tend to. So that's often why we get brought in for things like that. A lot of SMEs we work for. I actually work for a lot of SMEs in Sweden. I think this is a link to. Well, I know it's a link from one of our senior partners used to be in-house AstraZeneca, and he moved and carried on doing some AstraZeneca work. And because of AstraZeneca's links in Sweden, even though they've actually closed and moved from some of the sites where my clients are based, people have stayed and the relationships are still there. So I do a lot of work in Lund, in southern Sweden, where AstraZeneca used to have a site. But a lot of those are SMEs, and the same with UK SMEs. Mondol's still there, I think. Yeah. We obviously work for universities like University of Nottingham, tech transfer offices, charities, private individuals. We do. It's less common in biotech because of the cost involved in coming up with a new therapeutic or something. Tends to be a company rather than a private individual, but it does happen. My colleagues who work in engineering have more kind of garden shed inventors, if you like, that come up with something and want to file a patent application. So it does happen. And a really interesting part of my job is working for my equivalents in other countries. So the US is a great example because it's the biggest economy and has the most IP coming out of it. But all the US patent attorneys that are qualified as US patent attorneys, they all represent US companies and they'll get US patents for them. But when they want to get protection in Europe, they then come to people like me and get me to the European aspects of the protection. So once they file in Europe, I then handle that. So I then do a lot of liaising with the US patent attorneys about their clients and their inventors and get them their patents in Europe. And there's an element of travel over to the US to meet those clients we work with as well over there. So I find that particularly interesting. But just going back to how you qualify, there are lots of exams, as we were just talking about. If you're going to do this in the UK, you tend to qualify as a UK patent attorney and as a European patent attorney. Realistically, the useful one as a European patent attorney, virtually everything we do is European patents. We might file that initial application in the UK, but we tend never to actually do any examination with it. We let it go and just carry on with the PCT and the European that comes out of it. So all the work I do is before the European Patent Office, even though I'm qualified to do it before the UK Patent Office. I've done extremely small amounts of stuff with the UK Patent Office in the last 14 years. But we still have our clients, our trainees qualify in the UK because we think it's nice to be, and it's a very, very rigorous system to qualify in the UK. There's foundation exams. The way we do it, there's about 5 foundation exams that you do over the first 2 years, and then there's a set of qualifying exams you do after those when you've been in the profession 3 years, which sort of test. They design some papers to try and test what you're actual doing the job. So they you've got to, here's some information, draft a patent application, here's some information, respond to a patent office. They're actually incredibly unlike real life because they've been written trying to be, but sort of failed to do so. So it becomes you have to really learn the exam technique, if you like, to deal with those exams. So it can be quite difficult, and people quite often fail 1 or 2 of the exams the first time they do them. I failed one of my UK finals and retook it the next year and then did pass. But for most people that enter the profession, it's the first exams they ever fail, so it's quite tough to get your head around failing exams and but they are passable eventually. And then the European system is much more based towards the practice-based final exams, and you have to have been in the profession 3 years to sit those exams. So necessarily you tend to do the UK stuff first and then do the European qualification at the end. The biggest part of the training is on the job.
Why is Queen Mary University in London exempt?
Yeah. So there are certain, and I tend to skim past them because we don't ever send trainees on them. There are certain universities that do an equivalent MSc course that covers, an IP that covers the same information that basically can be used to stop you having to do the foundation exams. So you get a free pass through to the finals. And there's a course at Queen Mary, Brunel and Bournemouth. If you tend to work for a firm in the Midlands or North, you tend not to go because of the cost of sending people down to those courses. But yeah, that is another option. Good point, Steve. This is kind of a day in the life of a patent attorney, basically, and it's the sort of things you're trained on right from day one. So when you join as a trainee, I actually just had a trainee start last week in our Copenhagen office, so I'm going through this, trying to get them used to everything from the get-go. But right from day one, you start doing the job, and you just have a go at it yourself, show it to your trainer, who's a qualified attorney, and they sort of explain what needs to be done differently. Of course, there's going to be some bits, but it's all of these different things you'll start doing from day one. So providing advice about all different types of IP, what might be the most appropriate thing to do, drafting and prosecuting patent applications. So prosecuting is the word for going through all of the examination process with the Patent Office. Providing opinions on whether something's likely to be patentable and whether you've got freedom to operate, that other side of the coin. Patent oppositions that we talked about, so filing and defending those that I was saying I quite enjoy. Strategy, kind of like whole strategies for companies, like what they're going to do over all the coming years in terms of where to file patents, where to keep trade secrets. Advising on that is really, really quite a big part of my job. And then, as I said, providing advice about UK or particularly European specific law to our compatriots in the US, because they'll be like, well, we got this granted in the US, why can't we get it granted in Europe? And I have to delicately explain that the rules are different, and they might have to do something slightly different. And then at our firm, we do training specifically for the exams alongside this. So we do in-house tutorials for exams. There are external training courses we send trainees on to get ready for the exams. And of course, there's lots of private study in the run-up to those exams. And this is just a list of just highlighting really the different types of work I've done over the years and how it varies. So, antibodies, I keep using antibodies as an example, so it's probably not a surprise. I've done a lot of antibody work. I've done quite a lot of work based on GM bacteria and new methods of producing compounds from those. New medical uses, quite a lot of screening method work. Methods of reducing chronic inflammation. I've done some work on little clever devices that you clip on your skin and extract blood in a pain-free way. My clients, these last two examples, my two main clients in Sweden, actually, which currently do a lot of work for. One of them has a really neat in vitro test for working out compounds create sensitization of the skin. So for like potentially new skincare products, it stops people having to use animal testing. So they've now got a cell-based assay that's shown is pretty much as good. So that's quite a satisfying client to work for. And then the other one, they do diagnostic blood tests for early stage pancreatic cancer, and they've actually launched a product in the US last year that's doing really well, that can identify if someone's got pancreatic cancer much earlier than you'd ever find before, and that means they can then have the surgery earlier, well treatment early enough that they actually have a much higher chance of survival. So it's really kind of nice to be working on this kind of stuff and seeing how you're supporting these companies in being able to get these things to market. That's just the slide on further information. If any of you are interested in becoming a patent attorney, there's various sources of information. Feel free to ever email me if you want to. Inside Careers is a great service, and I'm not sure I think for things other than being a patent attorney as well, they are really good at providing a list of the sort of key companies that work in the field, and they provide information on sort of average salaries and things like that. So that's a good place to look at as well. And the other ones are the UK Patent Office, the European Patent Office, and we have a chartered institute that is responsible for UK patent attorneys that has information on it as well. So yeah, that's it really. Well, that was just a slide about Potter-Clarkson, which I just included there. But we're quite a big firm now. Interestingly, we went from just being an office in Nottingham to as of 5 or 6 years ago, having now offices in London, Stockholm, Lund, Copenhagen, Aarhus, and we have a space in Munich we can use when we're there, but all of these other offices we now have manned offices, so it's quite a change in direction to open offices in all these other countries as well.
It's a lot of big Scandinavian.
Yeah, and that's why we've done it, because we already were working a lot over there. So as well as the clients in Lund, we had a lot of clients from Stockholm as well, and the same in Copenhagen, and we just put offices where we were already working so we can have a team based there, and it was the way we could really increase even further than that business we're doing.
So I can view that with the links to Astra.
Yeah, historically, that's the reason the work in Sweden particularly has grown, I think, is the links with not me. No, so there was the senior partner, Steve McNeely, who joined probably 10 years before me. He actually worked as a patent attorney at Astra, so he brought it's easier to bring work when you've actually worked in IP at the firm. So I'd like to take credit for his offices, Steve, but no, I do spend a lot of time in the Lund and Copenhagen offices though, so I'm certainly helping those two offices get going. So yeah, any questions from anyone?
Tim, first of all, thanks on behalf of all the MRes and your latter generation ABT, it's now the MRes Biomolecular Technology. We all appreciate what you're taking time out. Valuable time. I hate to think how much you cost per hour.
Yeah, you'll get the bill, Steve. Are you joking? No, it's a pleasure. It's and thanks very much. And yeah, any questions, just let me know. And good luck with the rest of your course.
Tom, one question from me.
Yeah.
What's the difference? Because Prashant possibly going to do a placement in regulatory with James Parsley and Sendia and Bishop Stortford. What's the difference between regulation and patenting? Yeah, well, it's
completely different system. So it's a completely different legal system. All the regulatory stuff, all the regulatory hurdles you need to go through to get regulatory approval, it's kind of, well, it's similar in the sense there's a lot of information and a lot of requirements, but it's different in the sense that none of it's the same. So we don't, it's something actually, typically patent attorneys don't know anything about it because it's not part of the patent system. But interestingly, it's something that we've started to try and create an offering within our firm that we can advise a bit on regulatory. But it's mainly the way we're doing that is by linking into people that have that qualification and be able to say, look, we can work with this other regulatory expert to do that. So I'll admit I don't know much about it other than to know there's a lot of requirements that you have to and things you have to jump through, and not dissimilar to the same way to get a patent granted to get through that. But no, it'd be interesting.
Yeah. Because the thing about the patent route, obviously, is very lucrative at the end and very competitive, but you've got exams again.
Yeah.
You've got to do exams.
Yeah.
And you can fail them.
Yeah, and I mean, and that's why it's quite a well-paid job, because you have to go through 4 or 5 years of exams. So once you are qualified, you're quite hot property, because you're qualified, you've done all that. So another firm would quite like to recruit you, because they haven't got to pay for all the training. So that's why it tends to be quite well-paid profession.
And is it really, for these guys, if they wanted to go this route, is it really competitive to try and get in there? Do you need a lot of luck to be able to get through?
You do need a bit of luck. There's certain things you can do to make your application more likely to get through. I mean, I think one of the things we look for, obviously, it's, as I've said, attention to detail and language skills are crucial. So if you have any spelling mistakes in your covering letter, it's an easy bin. It really is. I mean, so making that, I think, trying to show why you're interested in doing it, why you think you'd be good at it, what's interesting about, particularly why patents are important, the commercial side of it. So if you can get any experience of why patents are important, so whether via the university or via talking to other companies or spending any time understanding the commercial importance of patents, I think that's what sets people apart, rather than just saying, yeah, I understand, I want to carry on looking at science, I want to be a patent attorney. It's nice to see a bit more understanding about why patents are useful and that kind of thing. People always ask, do I need to do work experience? It's so hard to get work experience. I mean, we very rarely offer it, because it's very hard to do, because it takes so much time to understand how the job works, and there's the whole confidentiality issue as well. So no one ever expects work experience, but just showing you've done a bit of research into the profession and why you think you'd be interested in it is important to get across, I think, in your covering letter.
Is a PhD essential or not?
It's not essential, not at all. No, I think a lot of people end up with a PhD because they've kind of drifted into doing a PhD, drifted into postdocing, and then sort of gone, oh, actually, I don't know what I want to do. And at that point, switch to be a patent attorney. So we have a lot of people come in after like a year's postdocing. But
of course, they're older.
Yeah, they are older. Yeah, I mean, my year group, there was 5 of us joined the same year, and we were all exactly the same age. I'd been at AstraZeneca. The other four had all got PhDs, but we all ended up being the same age for that reason. But we have plenty of people that do join straight out of university, out of their first degree. If they're impressive enough as a candidate, and put in a good application. I've recruited both. So Helen, who I recruited in 2017, my first trainee, she was straight out of university. She'd done a 4-year course at Oxford. And then Daniel, who I've just recruited in Copenhagen, he'd done a PhD and a year's postdoc in Copenhagen. So completely different in terms of backgrounds.
Right. And we're all at the offices in Nottingham, we're right in the centre.
Yeah, well, we're actually moving. This is actually our last month in our current office. We're currently in the Belgrade Centre, which is above Talbot Street Car Park, next to Rock City. Which is, yeah. But we're moving from there. We're moving to Chapel Bar, which is at the top of Market Square, where the Premier Inn is, and there's a sushi place and Las Iguanas.
Okay.
We're moving there.
It sounds good anyway.
Yeah, no,
it's not far from Biocity still, right?
No, slightly different, not far. I mean, Nottingham's not a massive city, so no, but we're always central. Yeah. Which is good.
Great. Right, team, any more questions?
For the IP courses, like the ones that I've seen that universities do, they're like a 1-year long course. So if you go the foundation route and do the exams on your own, is that similar timeline or? Yeah,
so the way it works, if the foundation exams, people only tend to do those if they've got a job as a trainee patent attorney and that their firm puts them through it. People do sometimes do the year courses themselves, sometimes to find out if they like IP enough or something. But if that year course does exempt you from the exams, realistically, you won't qualify any sooner, because for the European system, you have to have been working in the profession for 3 years under a qualified patent attorney before you're allowed to sit the European exams. So you might be able to qualify as a UK patent attorney quicker, but as I said, the European one's the more useful one, and you can't do that any quicker. So I think people perhaps are a bit surprised how little it does speed you up. It gets you out of doing some of the exams in your first couple of years, which is obviously a bonus. But I would say if you definitely want to become a patent attorney, I'd go for the approach of applying for jobs and get your firm to pay for you doing the exams rather than doing it yourself and having to fund that